About the event itself. This workshop was conceived by the countries constituting the BRICS community as a analytical session to examine remedial measures. BRICS community is a relatively new community in the world. It has a new establishment, just establishing its footprint in the world. Everything it's in its initial stages in terms of conceptualizing, policy making, implementing. A lot of questions have to be done and redone and analyzed and reviewed all over again, considering the particular aspects of the BRICS community. Back in 2012, they took a decision to hold such analytical seminars. The first one was convened by our Chinese colleagues. It was a high-level event. At that time, the participants came to the conclusion that these workshops must continue. Last year, the event was reconvened again in Brazil, and this time, for the third time again, we are meeting together. This time, the event is sponsored by the Eurasian Economic Commission. Our today's meeting is a part of a larger format, and hopefully this will be an effective contribution to the exchange of information and sharing best practices. Let me introduce the panelists, very respected and renowned members of the foreign trade community, experts. It is a rare and valued occasion when one can get hold of their expertise and meet them firsthand. These people represent the authorities that are competent in remedial measures, be it in China, Brazil, India, Russia. All of them are high-level officials, are experts, analytical thinkers. Mr. Datul from India, Madam Zhui from China, and Ms. Pereira from Brazil. And of course, our Russian colleagues and our colleagues from the South African Republic. Mr. Simonov, who is the director of the trade division in the WTO. Well, he doesn't need long presentations. He is a known person in the expert community. In the Secretariat of the WTO, he is responsible for dispute resolution. He leads a division which is responsible for negotiating rules, including anti-dumping rules, anti-dumping remedies. So I believe you will be well advised to avail yourselves of the opportunity to address questions to this very, very distinguished panel. I will be repeating the names. So, shall we start? We will will be now shifting to the English language.
Perhaps I would like to thank you again for coming here, for providing us opportunity to discuss such issues as indicated in our agenda. And I would propose to start our discussion with the first session, which was supposed to be devoted to decision-making and applying anti-dumping, countervailing, and safeguard measures in BRICS countries. And I would propose to provide a word to our colleagues from Brazil, to Elisa Pereira. Thank you.
Thank you, Vladimir. Good morning to you all. It's a pleasure for me to be here today and to share a bit of the Brazilian experience in decision-making process in trade remedies. Well, the creation of the trade remedies institutional and legal framework dates back from 1995, and when Brazil incorporated into its legal system the results of the Uruguay round. Therefore, what I'm telling you today is the experience that we have been accumulating throughout these 20 years. As you can see, in Brazil, the decision-making process can be divided in 3 steps until we arrive in the final step, that's the final collection of the duty. The first steps remains in the DECON, which is the Department of Trade Remedies, and who is in charge of initiating the investigation and taking decisions on dumping, injury, causal link, and whether there is countervailable subsidies, injury and causal link, and also whether there is an increase of imports, injury, and causal link in the case of safeguard measures. The DECON is also in charge of issuing preliminary determinations, extending the period of the duration of the investigation, and also recommending final determinations. In Brazil, after we take all decisions in the DECON regarding the technical issues, we submit our report and our determination to a technical group on trade remedies, which is the second instance of decision making in Brazil. The technical group will decide whether or not to recommend the DECON's determination, and then finally this determination will be raised to the last level, which is CAMEX. CAMEX is the Chamber of Commerce, and it's political and a political body that's formed by 7 ministers. These 7 ministers are the Minister of Foreign Trade, Development, Industry and Foreign Trade, under which the Department of Trade Remedies operates, Development, Agrarian Development, the Chief of Staff of the Cabinet of the President, Minister of Planning, Minister of Finance, and Minister of Agriculture. So the 7 ministers have a seat in CAMEX, and they need to make decisions by consensus on whether or not a provisional duty should be imposed, a final duty should be imposed or suspended for reasons of public interest, and whether or not price undertakings should be accepted. The DECON is under the structure of the Ministry of Development, Industry and Foreign Trade, and it's hierarchically linked to the Secretariat of Foreign Trade. In the DECON, the decisions are also split in 4 divisions, and each of these divisions are taking decisions regarding anti-dumping investigations, countervailing, safeguards, disputes, and anti-circumvention investigations. Finally, when you have negotiations and when you support the exporters abroad, when they are investigated abroad, we also make decisions along with the Ministry of Foreign Affairs, and that's all that's related to the decision-making process in Brazil. Thank you.
Thank you. If anybody has questions, later probably I would ask a question to you. Do you have any problems with, not problems probably, but do you have any role of competition authorities in making the decision in the process of anti-dumping, countervailing or safeguards measures?
Actually, we do have competition authority, but they do not interfere in our decision-making process. So we have different authorities. They are an independent body, and they do not interfere in our decisions. They can have one case in case of monopolies or oligopolies, companies being benefited with anti-dumping duty or countervailable duty, but this process is separated from our process.
Thank you. So, Madame Zhu, probably you would tell us something on this issue.
Okay, good morning, ladies and gentlemen. It's my pleasure to attend the Symposium Legal Forum and to make a brief presentation on the decision-making mechanism of trade remedy measures in China. I will first make a brief introduction to China's trade remedy administration and then share with you some information on the decision-making process when applied trade remedy measures. The first point, China's trade remedy administration. Here I need to correct a word of the first title of my speech outline in PPT. The word of also authorities should be replaced with the word of administration. China's trade remedy administration is mainly composed of three departments: the Ministry of Commerce and the State Council Tariff Commission and the General Administration for Customers. Among these three departments, the Ministry of Commerce is China's investigating authority, which is responsible for initiation trade remedy investigations for anti-dumping, countervailing, and safeguard measures, conducting and making determination of the investigations, putting forward the proposals on duties to the State Council Tariff Commission, and issuing the public notice of the determination and the decisions. The Tariff Commission is responsible for making the decisions to impose trade remedy duties based on the proposal by Ministry of Commerce. Normally, the Commission will, when it makes the decision, it will collect the comments and opinions from relevant government departments as well as related industry associations. The custom is responsible for carrying out the trade remedy measures upon the public notice of the decision on the determination. So that is basic outline of the trade remedy administration. The second point, I just want to make the very brief introduction on the involvement of China's trade remedy investigation authorities. The Chinese Investigating Authority was founded in 1997. At that time, the investigating authorities was composed of two ministries. The Ministry of Foreign Economic Relations and Trade was in charge of the dumping and subsidies investigations, and the State Economic and Trade Commission was in charge of the injury investigation. As a result of the institutional reform of the Chinese government in the 2003, two parts of the investigating authorities combined into one ministry, that is the Ministry of Commerce, under which two bureaus took their respective responsibilities of dumping, subsidies investigation, and injury investigations. In April of 2014, that is last year, to further optimize its functions, MOFCOM reshuffled the departments and established the Trade Remedy and Investigation Bureau. Its short name is TRB, which is responsible for all aspects of trade remedy investigations, including dumping, injury, subsidies, and safeguard measures. The establishment of TRB is a significant move to improve China's trade remedy regime. The newly formed TRB will further rationalize the trade remedy investigation procedures and conducting trade remedy investigations in a unified manner, thus to improve work efficiency and reduce the burdens of the interested parties. The last point, the decision-making process of trade remedy measures. Our trade remedy investigation process, including 4 phases, I think that's almost same as other members' practice. So the initial phase, preliminary determination phase, final determination phase, and the implementation phase. And during the initial phase, MOFCOM will decide on whether to initiate the investigation upon the application of the domestic industry. According to the anti-dumping regulation of China, the application of domestic industry must to fulfill certain requirement of the evidence and provide sufficient information required by the investigating authorities. And the TRB is responsible for examining such application and make the proposal to the minister from my ministry, and the minister will make the decisions on whether to have the initiation. So upon the approval by my ministry, TRB will issue a public notice of the initiation. During the preliminary determination phase, TRB will send a questionnaire to interested parties, including foreign export, domestic producers, and importers, and review the response thereof. After receiving the response of the questionnaires, the investigating authority will start to make on-site verification to the domestic producers. Upon the application of the interested parties, TRB may also hold public hearings to collect relevant opinions and comments from interested parties. Based on those procedures, MOFCOM will then make a preliminary determination on the dumping, on the trade remedy investigation, and the preliminary determination will be published by a public, will be publicized by a public notice, and also after the preliminary determination is made, TRB will disclose the facts of the essential facts of the determination, and then under the anti-dumping investigations, if the preliminary determination establishes the existence of dumping and the injury caused by the dumping import to our domestic industry, the customs will impose the provisional anti-dumping measures and requires the provision of deposit, bond, or other forms of security. Normally, the provision of a deposit is required. During the phase of final determination, TRB shall continue to investigate on dumping, subsidy, and injury. If an exporter of the dumping import offers price undertakings and TRB decided to accept such price undertakings, we will hold a negotiation with that exporters and try to reach an arrangement of price undertakings. Under normal substance situation or normal situation, after the preliminary domestic determination are made, TRB will conduct on-site verification on exporters. TRB may also hold public hearings to collect opinions and comments upon application by the interested party. That means we are provided 2 times of hearings on the request of the interested parties. Before the final determination are made, the TRB shall disclose the essential facts on which the final determination is made to the interested parties. After completion of all above-mentioned procedures, MOFCOM shall make a final determination. Just now, I already said the final determination will submit to the State Tariff Commission. Upon the approval, that commission, MOFCOM will make the public notice, and then the customer will carry out the measures. So that is the whole process of one trade remedy measures, applied after the investigation. So the main purpose of our process is to enhance the transparency during the investigation, to provide more opportunity to the interested parties and to figure out the fairness and reasonable measures of the investigation. So that's all my introduction. Thanks. Finish.
Thank you very much, Madame Zhu. Would be there any questions? Thank you, Mr. Dadu. Your turn to.
Thank you, Vladimir. You've taken a great initiative to bring us to what I believe is the most beautiful city in the whole world. I'm very happy to be here. I've been here 5 times, and I'm always happy to be here. Good morning to all the members in the audience. I believe they're very enlightened people, so I'll try and structure my presentation in two segments. I'll discuss the structure of anti-dumping and the decision-making process in India and the challenges that we face. I may take a couple of minutes more, but I presume you'll bear with me. The Director General of Anti-Dumping and Allied Duties, called DGAD, administers the anti-dumping and the countervailing duties in India. It is in the Department of Commerce, in the Ministry of Commerce, and is headed by the designated authority. Now, the designated authority is a recommendatory authority. It recommends the particular duty, and it goes to the Ministry of Finance, Department of Revenue to implement the duty, to notify the duty. There is a legal framework of trade remedies in our Customs Tariff Act for anti-dumping duty, safeguard duty, and the countervailing duty. In the case of safeguard duty, we have a separate Director General who recommends the duty. It comes to the Board of Trade headed by the Commerce Secretary of India, and then it goes to the Ministry of Finance, Department of Revenue for the final notification. India, like Brazil, has been a very frequent user of anti-dumping duties, and we have investigated cases against several countries. For your information, I'd just like to reel down some of them. Australia, Hong Kong, New Zealand, Bangladesh, Indonesia, Norway, Belarus, Iran, Oman, Brazil, Israel, Pakistan, Bulgaria, Japan, Philippines, Canada, Kenya, Qatar, China, Korea, Russia, Taipei, Malaysia, Singapore, Egypt, Mexico, Thailand, EU, Nepal, USA, and Vietnam. In our system, we are supposed to complete the cases in about 12 months, but in case for any valid reason we are not able to do it in 12 months, we can seek extension of time up to 18 months, which is allowed by the WTO. In the case of safeguard duty, as I mentioned, since there's a separate directorate, the number of cases done in safeguard is about 55 compared to about 300 cases that we have done in anti-dumping duty in the last 20 years. We started in 1995. This is about the structure of anti-dumping. I'll now move on to the challenges that we face as the decision-making authority while dealing with a large number of complex cases. The internal challenges are that we have approximately 98 to 100 cases presently under investigation, and we have just 6 teams to handle them. So each team has about 15 to 18 cases which they have to complete within the course of 12 to 18 months. The other internal challenge we face is that a lot of small and medium industry gets affected by dumped imports, and they are not in a position to file applications directly. And therefore, we need to involve the industrial chambers and industry associations to educate them on what is DGAD and how to file applications. The third important challenge is that while we are doing cases against other countries, cases done by other countries against India are not done by our directorate. We have been told that we will have to equip ourselves to do that work also, and that is an internal challenge to build teams to defend cases against India initiated by other countries. Some of you might want to know what are the products against which we have done most of our anti-dumping work, and I'd like to mention that they are mainly chemicals and petrochemicals, pharmaceuticals, textiles, fibers, yarn, steel and other metals, consumer goods, automotive components, plastics and plasticizers, electric and electronic equipments. If you ask me which are the 4 or 5 countries against which we have done the maximum number of cases, they are EU, China, Korea, and Taiwan. Now, the challenges that we face in terms of complexity are the following 6. The product under consideration. We face numerous challenges in finding out what is the best way to handle intricacies like multiple types, grades and varieties of a particular product, multiple technologies and how to handle them, multiple processes and different raw materials. The crucial criterion that we follow is the technical and commercial substitutability of the product. The second challenge is about determination of domestic industry. The problems arise because the applicant is also sometimes an importer, and therefore we have to decide whether they constitute the domestic industry. We need to examine the relationship between the magnitude of imports and the circumstances under which the applicant industry has taken recourse to importing these goods. In the case of soda ash, our High Court in Madras has held that the designated authority has full discretion to decide whether the applicant can be included in the scope of domestic industry or left out of it. The third challenge is the determination of individual margins for exporters and producers. The decision-making process here is very complicated because we need to seek information about the complete channel involved in the production and export of the subject goods, and very often it is not forthcoming. Determination of individual margins has important implications, and any errors can create disastrous consequences. The fourth aspect is confidentiality. We have to balance the commercial interests of the interested parties and safeguard their confidential information through a fair and adequate disclosure so that compliance of the principles of natural justice are followed. The designated authority has to scrutinize all claims of confidentiality made by all interested parties and allow the cases in which the claim is justified. The next issue is about circumvention of duties. We discussed this in broad detail in Moscow 2 days ago. This is an area of concern because complaints of measures to circumvent the applicable duty have been received, and India is yet to complete any investigation in this manner. The other challenges are determination of the types of anti-dumping duty, whether it should be fixed, a reference price duty, or an ad valorem duty. These are associated problems with each type, and generally the Director General of Anti-Dumping feels that a fixed or specific duty is appropriate in most circumstances. The last issue, and this I think is very, very crucial and very complicated, is how to handle multiple country duties. When duty exists on multiple countries and new application is received for duty on additional countries, we have to decipher which countries are countries of origin and which countries are countries of export. Now, whenever an ADD is recommended in respect of a number of countries, the goods originating in one of the subject countries but exported from other subject countries is subject to anti-dumping duty, we need to be very careful in terms of deciphering what the duty would be in the latter case. Because the fresh dumping from a new set of countries can also involve some of the present set of countries, and therefore overlapping takes place. In order to sort out the issues of such overlapping, which we find are very, very difficult at times in decision making, either the past notification has to be amended or a comprehensive fresh notification is required. And this is a tall order. We have done a case very recently, requires tremendous amount of application of mind to see that we do the right thing at the right time. There are some other issues which I'd like to highlight quickly. One is about transfer pricing policies with respect to the domestic industries. Some companies adopt the cost of production method, while others adopt the transfer value for captive production, which means the market value of the product. In multiple product companies, allocation of expenses poses a major problem, as the certified output is not only used in the product under consideration, but other products produced by the domestic industry which are not subject to investigation have also to be allocated these expenses. Some domestic producers tend to allocate the common cost of facilities and overheads more to the product under consideration and less to the non-PUC, which distorts the data. Another issue that we find creating problem in our decision-making process is the FOB CIF price claimed by the exporter, which sometimes does not match with the data of the Indian custom authorities. Therefore, it becomes extremely crucial while making the right decisions to carefully check whether payment for the invoice has been received by the Indian importer through the normal banking channels. Data from the concerned importer is called for to cross-check the figures reported by the exporters and the importers, and only then a final decision is taken. To conclude, I would like to say that while Brazil was the first country to start the anti-dumping process, while Canada was the first country to start the anti-dumping process, India and Brazil today are prominent users of this trade remedial measure. Thank you very much.
Thank you, Mr. Dadu. Would be there any questions? Thank you. And South Africa, who would be? Oh, okay.
Good afternoon. I'm Dmitry Katerina, St. Petersburg State University. In your presentation, you mentioned that there are some challenges during verification, mindful of high volume of cases. Which other authorities are participating in those investigations, minding of very high caseload per each group member? Who else is helping you in investigations? Which authorities?
We have, as I mentioned, about 6 teams comprising of a costing officer and a trade officer to do these cases. Now, it's very difficult to get experts to do this task, and therefore we are handicapped by just 6 teams. So when the volume of cases are high, the only way they can handle this is by putting in more effort. So while the normal government officials work 40 hours a week, the anti-dumping officials work 60 hours a week. They work on most Saturdays, they have to work to complete the task. But I must say that they are experts in their field. They're able to understand the complications quickly, and they're able to finish their task, in some cases in 12 months, and in many other cases in 18 months. There is no other outside assistance except in cases of litigation where we have counsels and lawyers who assist us in the court. I hope I've answered your question. Thank you.
Thank you. Another question?
Good morning. My name is Kirill Mladikar. I work for High School of Economics University in Moscow. And I teach WTO law, and I give my students India as an example of very extreme trade policy related to agricultural sector, because for some agricultural goods India has tariffs like 150 300%. And so I would like to ask you, do you use anti-dumping and countervailing duties in major cases for agricultural goods to protect them even more, something like to make them additional protection, like extreme tariff plus anti-dumping and countervailing measure? Or your trade policy, if to simplify, to protect agricultural markets by extreme duties and but to protect non-agricultural markets by countervailing and anti-dumping measures?
Very good question. Before I answer your question, let me tell you the agricultural structure in India. We have a population, as you know, of 1.2 billion people. But you may not be aware that India is the largest producer of milk in the world, largest producer of rice in the world, second largest producer of wheat, and the largest producer of fruits and vegetables. Despite being the largest producer, we have to import rice and wheat in very many years when the monsoon or the rains don't come fully. We also have to import milk at times when the demand is more than the supply. So India, despite being the largest producer in a large number of agricultural items, imports these goods. However, the imports of these goods are not in very large quantities, except in the cases of oilseeds and pulses, where the domestic production is not very high. To answer your specific question now, we have not imposed, I repeat, not imposed any anti-dumping, countervailing, or safeguard duty against any agricultural product, because we are always short of supply in these items, and we welcome imports whenever the situation demands. I would also like to mention that when I was making the presentation, I gave you the list of products in which we have imposed anti-dumping duty. And the largest number of cases are chemicals and petrochemicals, textiles, electronic and electrical goods. Agricultural goods have not figured in any case so far. Thank you.
Thank you. Any other questions? Thank you. So,
Thank you.
let's start with our South African friends' experience.
Good morning, everyone. Thank you. My name is Zoleka. I'm happy to be here to share with you the decision-making system for trade remedies in South Africa. I'm going to cover the establishment of ITEC, which is the authority responsible for conducting trade remedies in South Africa, and a little bit about what the authority's objectives are, how the decision-making body is composed of, and the functioning of the decision-making body of ITEC, which we refer to as the Commission. ITEC, the institution responsible for trade remedies investigation, is actually an acronym for International Trade Administration Commission of South Africa, and is responsible for conducting all trade remedy investigations, anti-dumping, countervailing, and safeguard investigations. ITEC as an institution was established through the Act of Parliament Act 71 of 2002, which came into effect in 2003. However, ITEC replaced other institutions that existed before it, with a long history dating back to the 1920s. And those institutions were replaced by ITEC in order to modernize the processes, to improve on efficiencies, and to move with the times, basically. So the first legislation, just along the lines of ITEC replacing other institutions that existed before 2002, may just share with you that, as an example, the first anti-dumping legislation in South Africa was passed in 1914. So we boast a long history of trade remedy investigation. Through the establishment of ITEC through an act of parliament, therefore the institution is independent and conducts investigations without fear and favor, basing decisions on evidence conducted and presented before the Commission during the decision making. The ITEC objectives, in short, is to foster economic growth and development in order to raise incomes and promote investment and employment in South Africa and within the customs union area by establishing an efficient and effective system for administration of international trade subject to the Act. Coming now to the composition of the decision-making body of ITEC. The Act which establishes ITEC makes provision for a chief commissioner who is the CEO of the commission and a deputy chief commissioner assisted by other part-time commissioners who can be appointed. The other commissioners can be appointed to serve or full-time or part-time, but mainly they've been having part-time commissioners in addition to the chief commissioner and the deputy chief commissioner. Commissioners are appointed from various backgrounds for expertise, and some from business, some various industry backgrounds. The Commission meets once a month to evaluate investigations conducted by officials. Maybe on the part of officials, I could just share that the trade remedy section of ITEC has about 20 staff members responsible for conducting investigations, who will then present the investigations before the Commission for decision making. The Commission is responsible for decisions to initiate or not to initiate an investigation, makes preliminary determinations, and makes recommendations to the Minister of Trade and Industry. Throughout the investigation conducted by the staff of the Commission, there are opportunities for interested parties to make comments and be heard, and for the comments submitted throughout the investigations to be presented before the Commission before the decisions are made. At the end of the investigation, the Commission will make a final determination, which is then presented to the Minister of Trade and Industry as a recommendation. The final determination on the investigation, whether or not anti-dumping duties should be imposed, is then made by the Minister of Trade and Industry, who, upon consideration of the recommendation from the industry, will either approve the Commission's recommendation, reject the Commission's recommendation, or send it back to the Commission for reconsideration. If the minister approves the recommendation of the Commission, then the Minister of Trade and Industry will request the Minister of Finance to impose the duties, and the duty will be in place for 5 years duration. And at the end of the investigation, all investigations, there are reports issued on completion of the investigations on everything that has been done throughout the investigation. Thank you very much.
Thank you. Are there any questions? Let me ask you a question. You mentioned in your presentation that the investigators are reporting on a monthly basis to the commissioner on the. At least it's written in your presentation that the commission meets once a month to evaluate investigations conducted by officials.
That's correct.
So what is the purpose of these meetings? What do they do there? Are they evaluating what is done in the particular investigation?
The staff of the Commission conducts the investigations, but do not have decision-making powers. So the staff will conduct the investigation and present the findings of the investigation to the Commission for decision-making. The staff are only there to assist the commissioners in making the decision, but they do not take decisions. So we'll collect information, analyze, and make recommendations to the Commission on what the decision would be. When the Commission meets once a month, as already indicated, then the Commission will be considering reports that the staff would be presenting to the Commission on the investigations conducted. So when the Commission meets every month, these reports prepared by the staff would have already been sent to the commissioners. So when the commissioners come for a meeting, they already have the reports they've read. It's a question, in the meeting, it's more to ask questions to the staff and to get clarity on certain issues about the investigations that the staff has conducted before they can arrive at a decision.
So if I understand it correctly, they evaluate the reports with preliminary or final results. And one more question. From your experience, what is the background of the commissioners? How competent they are in such a specialized area to understand your analysis results?
The commissioners have from various backgrounds. Some have legal backgrounds, others are experts in business management, others have economics backgrounds in various industries, work in various industries. So it's a mixture of expertise within the commission itself.
So they look into the results more from the general logic and their general economic or legal background.
Yes.
Thank you. Any other questions?
Can I have one? Regarding the Commission, I understand that your final decisions on application of the trade remedies are applied on a SACU-wide basis. Do you have any involvement from other SACU members at the decision-making stage of the investigation?
Not at the decision-making stage. We conduct investigations on behalf of the whole of SACU. We involve SACU members throughout the investigation if they have comments or there's information that other SACU member states would like to be considered during the investigation. They can participate, but decisions are taken by the Commission only.
Thank you.
Thank you. So any other questions, please?
Thank you. Maxim Schmel of the Eurasian Economic Commission. I have actually a question to link both the presentations by South Africa and China, if we can, because we heard from our colleagues from India, and I know from the experience we had in Brazil about teams, right? So there is a team of investigators, some people who investigate injury, some people who investigate dumping, or they do both. For instance, in Brazil, it's both. And in India, it would be different people, a costing officer and a legal officer. In China, how many people would you have investigating, and whether you separate between them? And how many people would there be, how many officials, investigators in the authority? And the same question would go to South Africa as to how you separate those responsibilities between investigators. Thank you.
Just now I mentioned the new investigating body, that's TRB, founded last year. So since after this new investigation body founded, the old investigation task combined into one bureau, and then we have several divisions which are in charge of trade remedy investigation. That's about initiation division, and plus 5 investigation divisions, and also plus the rules divisions. Together we have 6 or 7 divisions which can conduct investigations of the trade remedies. If there's one case, normally, if there are application, normally the division of the initiation will be responsible for examining the application. So after the decision made by our minister to have the initiation, then the case will turn to the one investigation division. Normally there are 4 or 5 persons, this one team, in charge of the specific case, and we don't make the dumping investigation, injury and counseling assessment separately. So that is a division director, like Mr. Lin Hong, like Mr. Li. The division director will make the allocation of the work to who will responsible for dumping investigation on company. Normally the case involves several countries, so maybe 2 persons responsible for the investigation against an import product from that countries, and another 2 persons is responsible for the investigation of import from the second country. So those 2 persons or 3 persons will conduct all the investigation, injury investigation, dumping investigation, sometimes subsidy investigation together. So now that's teamwork, not conducted by a separate personnel. It's division. So the division in my bureau is very important. Okay.
Thank you, Maxim. In our case, I indicated that in total we have, in trade remedies section, we have a total of about 20 investigators who we allocate teams per investigation. Our teams usually consist of 2 team members. But depending on the complexity and the size of the investigation, sometimes you'd have 3 or 4 investigators, but usually it's 2. And they'll do everything. They'll conduct the investigation from start to finish. Thank you.
We have for 40 investigators, just investigators, 40 personnel, 40 persons who can conduct the investigations.
Thank you. Any other questions on this session? Thank you. I would propose to go to the next session and ask Mr. Human to provide us with some information on a very interesting topic of Doha Round.
Okay, good morning. Thank you, Vladimir. My name is Jan Human. I'm the director of the Rules Division at the WTO Secretariat. So first of all, thanks for the invitation from the Eurasian Economic Commission. I'm a little bit of the odd one out. As you know, it's BRICS colleagues to my left and to my right, and I'm sitting in the middle, trying to keep the peace. Sometimes it's more easier than other times. Now, just to put things a little bit in perspective, the 5 BRICS countries represent, or they account for, 1/3 of all anti-dumping investigations done by WTO members since 1995 till the end of last year. So the 5 out of 161 members, accounting for 1/3 of all anti-dumping investigations. But on the other hand, the colleagues will also tell you that they're pretty balanced, because the 5 BRICS countries also represent 1/3 of all anti-dumping investigations done between 1995 and the end of last year have been done against BRICS countries. Now, they're friends, but they also do things to each other, because there are also many investigations initiated by BRICS countries against other BRICS countries. So they're pretty balanced lot. Now, being a member from the WTO Secretariat, all my comments will be in my personal capacity and not to be attributed to the organization. But it's good to be with the BRICS colleagues and also with you today, seeing that we're celebrating this year 20 years of the WTO. So it's good just to take a little bit of stock of where things stand and where things could or should move to into the future. Now, the topic that we're going to cover now is the review, updating the anti-dumping agreement. I'm going to give you a little bit of a background into the history of the negotiations, and I'm not going to go into the detail on some of the really technical problematic issues, but then to conclude with where things stand and what might happen in the next couple of months, seeing that the Doha Development Agenda has to come to a conclusion sometime or the other. So let's just go back a little bit, if I can get this to go. Okay, why did members decide to negotiate in Doha in 2001? That's 14 years ago. First, in the conclusion of the Uruguay round, there was what we call an inbuilt agenda. That means ongoing negotiations on agriculture, on services, and also to improve the dispute settlement understanding. That is when there are disputes amongst the members. But there was also impetus after the events of 9 September 2001, where the world rallied and thought that it'll be good to show that the world is united, and let's try to improve things for the whole world. And the members also felt that after 5 years after experience with the Uruguay Round agreements, let's review it and see whether we can make further improvements. Because there's also, in between 95 and 2001, an increase in the users of trade remedies, in particularly anti-dumping. If you look at this slide, you'll see a significant increase from 95 to 2001, and also the number of members who've used the instrument. So a little bit of an increase, because you'll see in 95 or in 1980, there were 5 traditional users. They called the traditional users of anti-dumping. And then in 1990, a few more, and 1995, 18, of course, counting the EU or the then EEC only as one. Well, because what is interesting is that, of course, in the conclusion of the Uruguay Round, all members were automatically signatories to all the agreements. So all WTO members then could use the anti-dumping agreement or any of the other trade remedies agreements. But of course, with anti-dumping, it is not mandatory to have a trade remedy system in place. But if a member would choose to do so, then of course they have to follow the rules of the game if they want to impose measures. So that's why the members then decided in 2001 to agree to reopen the anti-dumping agreement. But it was quite problematic, because in 1999 the members had a so-called failed ministerial meeting. They went all to Seattle in the west coast of the US to launch a new round, but they couldn't agree. And one of the main reasons was they couldn't agree whether the anti-dumping agreement should be reopened or not. So then it took them another 2 years. So anti-dumping has been on the background and an important part of the whole process since 1995 for all kinds of reasons. Now, I also mentioned in one of the previous slides that there was also a problem with dwindling fish stocks, because you wouldn't believe me, but in the rules negotiating group, the members cover not only anti-dumping subsidies, but also fishery subsidies, because there was a feeling amongst members that because of subsidies to fishery industries, that contributed to overcapacity and overfishing and dwindling fish stocks, which is a huge problem for the whole world, because there's a high reliance on fish for protein needs of many people all over the world, apart from the fact that it generated a lot of income. But it was fishery subsidies negotiations that was included in the rules negotiating group because of the possibility to have trade-offs. Those not interested in anti-dumping as such, they could have been interested more in the fishery subsidy side. So it was trying to create an opportunity for trade-offs. Then in Doha in 2001, the members decided to negotiate with the Doha mandate, as we call it in paragraph 28. And the Doha mandate says, on anti-dumping, because we're going to focus now only on anti-dumping, negotiations aimed at clarifying and improving disciplines in AD and subsidies and countervailing measures agreements, while preserving the basic concept, principles, and effectiveness of these agreements and their instruments and objectives, and taking into account the needs of developing and least developed countries. Now if you look at it, this paragraph means different things to different negotiators. If you start off with, first, aimed at clarifying and improving. Oh man, they spent hours and days on the work improving. It's not strengthening, it's improving. What does improve mean? Does it mean strengthening, elaborating? What does it mean? So the negotiators see it with coming from different perspectives. So the negotiations start off, and it was quite problematic, right from the word go. It covered a large number of issues. Almost all the articles of the current agreement were reopened, and mostly technical issues on methodologies, but also some general issues on transparencies, technical assistance, that is our jargon for training, and also reducing the cost of investigations, because investigations have become quite costly and resource intensive. Now, if you then look at the negotiations itself, there were primarily two strong groups of, or two sides to the negotiations. The one, and you still have it today, you have the fans, as we call them. Now, in the WTO, the bureaucrats like to use all kinds of acronyms, so they call themselves by all kinds of different names. So we have the fans group. Now, the fans group, they're not fans of anti-dumping. They're actually called the Friends of Anti-Dumping Negotiations. That's where the word fan comes from. So they're not friends of anti-dumping, exactly to the contrary, some would argue. They're friends of anti-dumping negotiations. So they like to negotiate. But they still called the fans. Now, amongst the fans, you would count in the early days Brazil, Chile, Colombia, Hong Kong, China, Israel, Japan, Korea, Norway, Switzerland, Chinese Taipei, and Thailand, sometimes others. Now, my friend Eloisa might say, oh, but Brazil, we're a fan, yes, but are we really still a fan? We have Japan, very much a fan in the early days, but Japan is also starting to become more of a user of anti-dumping. And my friend Madame Jo will remind us that Japan initiated an anti-dumping investigation against a steel product from China earlier this week, or last week, towards the end of last week. But what they said is, according to them, there's been a huge abuse of anti-dumping, and that needs to be addressed in the negotiations. And also to avoid the excessive burden on respondents, that means importers and exporters, when they have to respond to an anti-dumping investigation. And also to improve the transparency and also the fairness of the whole process. So that's the one side. Improve things, make things better, basically strengthen the agreement. Then on the other side of the divide, you have the US, where they say, okay, let's improve the effectiveness of trade remedy law, so make it more sort of workable. Yes, improve transparency, but also a very strong point emphasized by the US, enhance disciplines to address trade distorting practices. To go back to the basic rationale, why do you have an instrument like anti-dumping or trade remedies? To address certain distortive practices. That's the way how they see it. And then sort of a little bit in between, we have the EC, who said, well, they focused more on the transparency side, and they made a proposal on a review, not a review mechanism, but sort of a transparency mechanism. Yeah, you can call it a review mechanism, that there's overall more transparency in the whole process. Now, of course, the negotiators started in 2001, lots and lots of proposals, and but they're sort of going a little bit round in circles. Members will excuse me for telling them that they've been going round in circles, but if you haven't gone to a conclusion after 14 years, sometimes you have gone a little bit in circles. Sometimes this way round and sometimes the other way round, but not coming to a point. So then in the Hong Kong ministerium, the ministers instructed them, basically get your act together and start working on basic text-based proposals. Because up to that point in anti-dumping, they only focused primarily on conceptual ideas. So in Hong Kong, ministers said, okay, move. And then they started to move. lots of proposals starting in 2004, elaborated proposals, and in the end the whole idea was to conclude the round, I think it was about in 2006, 2006, after 5 years of negotiations, and then the first chairman's text was put on the table by Ambassador Galmez. He was ambassador from Uruguay, and he was the chair. He put a text on the table. And that was a very problematic text. Members were extremely upset with his first text. Why? Because on two very sensitive issues, he made life difficult for the one side and difficult for the other side. That was on the issue of zeroing. On the issue of sunset, he also gave a little bit to the one side, and it took away a little bit from the other side. So what he did was he tried to balance things by giving something on zeroing to the one side and something on sunset review to the other side. But that was not to the liking of the negotiators. So they heavily criticized it. And to cut the long story short, there were also then a second chairman's text, and then a third chairman's text, which was so-called the Easter package of 2011. And where we stand at the moment, the last text was on anti-dumping, a text, yes, on the 12 very problematic issues, brackets, describing the problems on the 12 issues. And then what we call unbracketed issues. And then that was on anti-dumping. Then we also had the negotiations on horizontal subsidies, where there was also not basically a text, only a description of the issues, and then on fisheries subsidies, what we call a roadmap, just describing the problems. So just to give you a flavor of where things stand, is a text, but with the sensitive issues in brackets, where there's no movement towards a consensus, and unbracketed issues, sort of smaller issues where the chair felt that there could be consensus emerging soon. But that was, that's where things stand. So I'm not going to go through all the bracketed issues. You can, for bedtime reading, if you're interested, you can read it. I'm going to skip now and go to the last slide, which is on where do we stand now. So that was, in 2011, we had the third chairman's text. And that means, what, 4 years ago? And nothing has happened in between. And now, after the Bali Ministerial in December 2013, there's now more of a pressure to get things going and to conclude the DDA, because things can't be unsolved and unresolved forever. Members really have to either conclude the round in whatever form they deem necessary, or to conclude that there's no conclusion to the DDA. So things have started to heat up a little bit in Geneva the last couple of months, starting towards the end of last year, where the chair conducted informal consultations on a bilateral basis to get members to refocus on the rules negotiating group issues. And they then decided that the Secretariat should organize a briefing session, which we did early in May, to give members a historical perspective of what happened without sort of passing judgment on where things stand, just a very objective assessment. Then the Director General had a green room meeting with a core group of ambassadors early in May, just after the briefing session, where he asked them to focus on what they think are doables in the rules negotiating group negotiations. Because the problem that the members face is that there are three big elephants in the room. The one is no progress on agriculture, no progress on services, no progress on market access. So it's market access, services, and agriculture, the big three elephants in the room. And members, the negotiators are clear that if the big three don't move, the other issues will also not move. So why waste time on the other issues if there's no progress on the big three? And that's what we call the sequencing problem. Because if you move on agriculture, then there will be a movement on market access. If there's movement on market access, then there will be movement on service. The three of them lumped together, but the one half a step and a step behind agriculture. The general feeling in Geneva is that agriculture will have to move first. That's unlocking the negotiations. So that's putting our chair at the moment, Ambassador Wayne McCook from Jamaica, a little bit on the spot, because he cannot sit back doing nothing, because then if the other three, the big three elephants start to run, and as we know, if elephants start to run, our colleagues from Africa will tell you, and from India, get out of the way, because you have to go for cover. So what do we do then with the rules negotiations? It might then be that the rules negotiations, an anti-dumping agreement, improvements to it, might fall by the wayside because there might not be time or inclination to look at it. So that's difficult for the chair, because for the fans, some of them say that anti-dumping is a very important issue, and there can't be any conclusion to the DDA unless there's a sort of progress and something to be harvested on anti-dumping. So the chair will be having a meeting tomorrow with the members in a follow-up to the meeting of the Director General with the 20 ambassadors, to put more pressure on them to find out what do they think, which issues might be harvestable or might be doables. So that meeting will take place tomorrow, and he's starting off to look at transparency on WTO, what we call WTO transparency. How to improve transparency in notifications, as the standard WTO notifications, because the members have set themselves a deadline of the end of July to develop a work program to conclude the DDA in December, between the 15th and the 18th December, during a ministerial meeting in Nairobi in Kenya. So that's where we stand now. I'd like to hear from the colleagues how they think what might happen or what might not happen in the rules negotiations. So that's just a little bit of a bird's eye view of where things stand right now. Yes, that's the end of my presentation. Vladimir, will you manage?
Probably first of all, I would like to ask if there would be any questions to Mr. Human, and I would like to thank him for a very helpful presentation to start with the discussion on this issue.
Thank you, Mr. Human, for your very informative presentation. I have a question. We all say that things have changed a lot in the area of trade remedies after the Doha Round has started. So the negotiations may be different in the future. So what do you think? What major changes in your mind have taken place after the starting of the negotiation, and what do you think those changes will, shift the future trend for the rules negotiation if we manage to restart the process? Will the standpoint of fans be closer to the other side? Will the different views be easier to get closer? So what's your expectations? Thank you.
Thanks. That's a bit of a difficult one. Things have changed. Primarily, we've seen the financial crisis since 2008, but what we haven't seen since 2008, one would have expected a significant increase in trade remedy action, particularly and anti-dumping after the financial crisis, which hasn't happened. Last year, the members initiated 237, 238 new investigations against each other, which is quite a low compared to previous years. The highest was just over 330 in 2002, so there's been a significant downturn in anti-dumping action. But things have changed because of the financial crisis. We see little interest, that means in diplomatic speak, no interest in really pursuing negotiations on horizontal subsidies, industrial subsidies, because of the financial crisis and what members did subsequently in reaction to the financial crisis. But what we've seen in anti-dumping, the world of anti-dumping, a number of members have changed, made effective changes to their anti-dumping legislation. Why? Because of domestic concerns or domestic pressures, and adjusted their legislation. Now, that's where I have to be a little bit careful as a member of the Secretariat, how to typify these changes. But if you look at the changes, you can see that there's sort of a rebalancing, if you want to call it that way, in trade remedy action, understanding that there are rules, there are gaps in the rules, but you have to make sure that the instrument is workable. Because if your trade remedy system is your safety net, it enables you to negotiate. And if it's too rigid and you cannot have the breathing space, then history has told us that members then resort to other measures. And the other measures might not be transparent. So they go sort of a little bit, I don't want to use the term under the table, but they do things in a less transparent way. So you have to find a balance, and perhaps that is what we see in members' legislation. And of course, the world has also changed. You see, it's come back to fewer investigations because of the world of manufacturing has changed. Globalization has played a major role. What do they call it? Global value chains. How do you do? The colleagues will tell you to do an anti-dumping investigation these days is pretty complicated. But it can be that members feel that, okay, things have stabilized, the rules have worked well. Yes, there are huge concerns, but let's not be too ambitious.
I have a small question, sorry. You mentioned Japan is a friend of the anti-dumping nations. In a recent conference in Delhi, the DGAD of Japan was there, he made a presentation, and he said in the whole year he does only one case. How does he become a friend of the nations of anti-dumping if he does just one case in the whole year? He initiates only one case in 1 year, and he does that case throughout the year. Japan. Yes.
Yes, well, Japan, because of historical reasons, Japan has been a very strong leader of the fans for quite decades. And primarily, and it's no secret, it is what they perceive what happened towards the concluding times of the Uruguay round, that they felt that they were done in, that they didn't get what they thought they were getting. And they always thought that perhaps it was because they're not experienced in anti-dumping or experienced enough in understanding the real technicalities of the instrument. But Japan has its own investigating authority, and from time to time they do investigations, but they're more active these days the last couple of years. And Japan has also made significant changes to its anti-dumping legislation. Now, on the one hand, it was also being sort of a leader of the fans but also opening the door a little bit for its own domestic industry to be successful in bringing an application. Because initially the threshold for Japanese industries were, according to them, extremely high. So there have been some adjustments. But it's also the role that I think that Japan has been playing in the world economy and in the world of trade, where Japan was primarily, I would say exclusively, but a very, very strong exporter from the late 60s into the early 90s, mid-90s. And now, with a very much developed market, more receptive to imports. It's how their trade system developed from a very strong exclusively exporter to more importing. Because if you take Japanese exporters, the number of initiations against Japanese exports, it's very low comparatively to what happened in the 70s and 80s.
Thank you. Any other questions?
Mr. Human, I got another one. Can you please elaborate a little bit on the influence, if any, the WTO litigation has had on the Doha Round negotiations? So for the cases taken through the DSB and successfully passed appeal process, do you feel that members tend to use those decisions as a basis for their negotiation positions? Thank you.
Yes. Well, what we've seen is, unfortunately for me and my division, a significant increase in the number of disputes amongst members on anti-dumping. Just to give you an idea, from mid-December till when I left Geneva yesterday, members have established and composed 9 anti-dumping and subsidy panels. So a significant increase in disputes. So the question is whether that's playing a role, the jurisprudence, whether that's played a role in the mindset of the negotiators. Now, if you ask me personally, I think yes. Yes. Because, of course, when you have a rules-based system, what we've seen since 95, that's not to say that the GATT system was not rules-based. It's a bit of a misnomer, and I think, I would say, ignorance of what happened in the past. It wasn't law of the jungle, but there was more scope for finding diplomatic solutions to the problem than there is now. Today in the WTO, it's very much a legal process. Now, what we find is, and that's sort of the problem that members are experiencing with jurisprudence in trade remedies, because the panel and the appellate body can say, okay, you haven't really followed the rules, bring your measure into conformity. How do you do that? They don't tell you how to do that. Okay, so you go back to the drawing board. Mr. Radu goes back and he says, okay, let's recalculate the measure. Okay, and then they do the recalculation, and then they get another challenge. Now, India hasn't been challenged. I'm just using India as example. Okay, then they implement the ruling, but then they get another challenge. And then a panel might again tell them, oh, that's wrong. And we all know for economic operators, you need to have legal certainty. So in my view, in my personal view, I think it's playing a huge role in the mindset of negotiators, that it's very, very difficult, because the jurisprudence has added sometimes to legal certainty, but sometimes to legal uncertainty. And that's very difficult for them to deal with, because they, at the coal face, they're getting the brunt of the exporters and importers and domestic industry.
Thank you.
Mr. Human.
Good morning, everyone. My name is Nikolai Mizulin. I am with the law firm of Mayer Brown in Brussels. I have 3 questions, if I may. two questions to Mr. Human and one question actually to everyone but him. So the first two questions to you, Mr. Human, one is if you could comment on the issues where we actually have consensus. So what are the unbracketed issues in the text? The second question, more of trying to see the broader picture, and the question is, assume we kill the three elephants in the room, right? If we have an agreement on market access, we have an agreement on services, we have an agreement on agriculture, do you actually think we're going to agree on the improvements to the anti-dumping agreement? And I ask because I practice a lot in the European Union and the United States as well, and the mood right now in terms of reforming the domestic trade remedies legislation is actually rather protectionist, and there is a big drive towards strengthening the application of the anti-dumping measure in a sense of making them a more effective barrier to trade. And this drive actually has to do with China. And it has to do with China, it has to do with 2016. And here's the third question, actually to everyone here, and in particular to India, to Brazil, and to South Africa. We in the European Union, the United States, Russia already given an answer, in fact, recognizing the market economy status for China. But what is your thinking on what you will do in 2016 in terms of, say, implementing the paragraph 15 of the Chinese protocol accession? Thank you.
Okay, on your first question on the unbracketed issues, there are a lot of issues that are smaller issues, less controversial issues. Some of them are just sort of housekeeping, cleaning up some of the leftovers in the Uruguay round, because there were some of the issues where the negotiators were too much in a rush to conclude things that they missed some glaring mistakes. If you just take, for example, in the annex to the anti-dumping agreement, where the relevant article in the agreement talks about facts available, but the annex still refers to best information available. And that was a big issue in the Uruguay round, but there wasn't time, and the legal scrubbing was not thorough enough to look and to change it to facts available annex. Because best information, what does it mean? The appellate body interprets that as it has to mean something, because negotiators never slip and make mistakes. So they started to interpret best information available. That's just an example. But there are quite a number of them: refund procedures, provisional measures, post-determination calculation, disclosure, evidence. I have a comprehensive set of slides on the unbracketed issues, so I can send it to you by email if you're interested. But sort of smaller issues now, on the one hand, one could say they're unbracketed issues, and that's why the fans of the view say, okay, they're unbracketed, so let's pocket them, let's bank them. And then the other side say, no, it's not that simple, because we decided or agreed to unbracket them on the condition that nothing is agreed until everything is agreed. And it might be that Karina has decided to say, okay, let's take the brackets away, with the expectation that that will put pressure on you to agree to remove the brackets on some of the big issues of interest to her. And that's also an issue for negotiators to sort out. On the second issue, on if the big elephants start to move, whether there will be progress on anti-dumping, I think that's for the negotiators to decide, because we all know how negotiations work. I'm only prepared to give something if I get something back. So the question for the US Congress is whether there will be something of interest to them to make it worthwhile to agree to changes to the anti-dumping agreement. Now, keeping in mind that in the US and many members, you have very strong lobbies, different lobbies. Now, what the lobbies in the US shouldn't underestimate is that the US now have the data, you will have to go through the data set. The US is no longer an insignificant target of anti-dumping action. It is a significant target of anti-dumping action, or affected by anti-dumping action. Now, okay, you can say that one measure imposed by the US might have a much larger trade effect than a measure imposed by Corina in South Africa against frozen chicken portions from the US, for example. It might be very small in the bigger scheme of things for the US, but the US is no longer only a user of anti-dumping, it's also a factor. And if you look at the data, increasingly so in the last 10 years. But you have to look at the lobby groups in the US. Now, it might also be, there's also a school of thought that say that if you look at for the US, transparency was very important, and is still very important in the rules negotiating group. The US has, and it's not a secret, and it's generally accepted, not one of the most, but the most transparent anti-dumping system. The lawyers in Washington boast that they can calculate by 0.5 percentage point the final measure, the final duty. So it's very transparent. So it might be interesting for the US to have a little bit more transparency all over the world, but that's for them to decide. On your third question on the 2016, from the WTO side there is the protocol, there is on Chinese accession, there is a provision dealing with this issue, and it's for members to how they see it. But perhaps I'll retire before then, if you read between the lines.
Well, to answer your third question from the side of India, I would only like to succinctly say that we will wait and watch.
Anybody else? It's not a simple question, I understand, but...
For the Brazilian point of view, I'm sure that this is not a decision that the authority will take. This is a decision making that will be taken at a higher level. And I'm sure they will consider the bonds that we have developed with China. And our industry will also understand that.
For South Africa, I can't imagine what would be happening, but at the moment, China was granted market economy status in 2005 already. So 2016, I can't imagine it being a big issue.
So may I make some response to these issues? I think, just as Human said, there is a protocol of WTO accession to of China accession to WTO. So that protocol is part of the WTO rules. So each member has the obligation to respect and observe these rules, and also China has already, accepted that provisional rules, or even that rules is not reasonable, is not fair, that there is clear deadline for that rules, that the deadline is 2016. So that means that after 2016, that rules has been expired. it must be terminated. If there is some debate or there argument on that rules, it's cannot accepted by us, you know. So since if there can be used again or continue, that means the deadline 2006 is it's meaningful. So that's why I said after 2016, that rules has been must be died and must be terminated. And from 2016, China has the same right, same situation with other WTO members. We enjoy same right, same situations. So if other country if other members think that rules could be used again or continue, I think as an authority of Chinese anti-dumping authority, I think that rules could be used by us also. Yeah, since if the time limit or the deadline has been cannot mean anything. That means that rules could be used by anyone. That's my understanding for that. So even if some members want to use that methodology again after the 2017, okay, China has a right to bring the matters to the WTO dispute settlement body for the litigation, WTO litigation. But also we can also keep our right to use that methodology also if other people use that methodology after 2016. But now we can use that methodology. That is only focused on to China or some other members when he has such commitment or protocol when accession to WTO. But you know, the rules has been failed to be used. So there's no special rules after 2016. No special rules for China. China will enjoy the same situation, same treatment, same rules. So if other people can adopt the methodology, that means we can also adopt that methodology. So we bring all the case to the WTO. So human, you will have a lot of job to do, many cases. Not only the case we suit other members, but also the case maybe other members to China. So we also want to use such methodology after 2016. So we watch.
I would like probably to add something to it. I'm not quite sure that it would be easier for us to conduct investigations against China if there would be no market economic status in Russia with respect to China. But we don't see any specific concerns and difficulties in calculating normal value on Chinese market compared to cases in other countries. So it's not quite clear to us why it's such a point in time which is, I would say, afraid by some authorities. But what I could be quite happy about is that EC would be one of the most experienced agencies in conducting such case in 2016, since we would have some experience in that compared to others. But frankly speaking, in our investigations, we do face some problems with data from China, with cooperation, for example, of course, with language, because it's quite a complex language. But In most cases, and we've got a lot of cases against Chinese products, we don't see that it's really different from companies from other countries. Yes, there are some specifics, but the basis and the basic issues are quite the same, and the basic problems are quite the same. With the questionnaires, with the schemes of sales, with the levels of trade. It's almost the same, or the same methodologies are applied with respect to, for example, Ukrainian products or Chinese products, and they work in both cases.
The basic rules of ADA is that the anti-dumping authority should use the data of the figures come from the original exporting country. So if you want to use the figures or data from the third country, there's very strict strict limitation. I didn't say there's some permission for normal investigation to permit the members to adopt such methodology as surrogation methodology. So, but I find that recently there are some new trends that the Article 2.21, 11, the special situation, the clause of special situation market, has been used by some members already. So I find the member always want to explore the use of this instrument. So we already studied that performance. And also we think that maybe after 2016, more members will use that special market situation, that clause to be used. Whatever your market or non-market economic country, so it could be used by any members. So. The problem is how to define the concept and the criteria of special market situation. That's important for all of us, I think. Saying that you don't need use this methodology for the political purpose, just for the technical purpose. You can explore the methodology to use the figures, data from the third countries. I mean, for example, if I think the Article 2.2 said if there's no domestic sales, the two methodology can be used. One is the constructive normal value, another is use the price of exportation to a third country. So that would be provide some rooms, spaces for the members to use the surrogate methodology. I just find that that's a problem. Mr. Human?
Yeah, I have something to add, especially for Madame Zhu, as a person who spent some time in China doing verification visits to Chinese companies. I'm afraid that use of market economy status can create further challenges to the companies participating in the investigations.
Problem for us, I already told you, maybe that's a challenge for other members. If other members continue to use that method, that means China can also use that method. That's my...
Yeah,
I have to choose that. In the past, I cannot use that methodology, but after 2015, I can. I have right to use that methodology also.
Well, you see, I was quite amazed when we had a verification of one company in China which had an experience with the European Union case previously, and they were kind of amazed how deep an investigating authority should go when reviewing normal value information, costing data, compared to the European Union experience. So it was quite a challenge in terms of the work to them. But they were kind of prepared to that. But in general, I think that companies which are going to be verified by various investigating authorities will face this kind of challenge of better preparation for this information gathering process.
I would propose probably to get back to the Doha Round issue instead of this very important and very interesting but sensitive question of non-market economy issues. Mr. Human, what I wanted to ask is that, in our opinion, in last 2-3 years, the decisions of appellate body and panels in disputes related to anti-dumping measures significantly change the understanding of certain principles or regime which should be applied procedure in terms of procedure in anti-dumping investigations. What I could mention is, for example, access to information, access to non-confidential information, ways of preparing non-confidential versions of confidential information, access to information for the interested parties, etc. I mean those decisions on 6.5, Article 12. For us, it's quite a different story compared, for example, to what was in 2012 or 2013 when Russia acceded to the WTO and we understood that we should comply with a certain level of requirements. But now this level of requirements is, in our opinion, has changed. And it has changed due to the decisions of the dispute settlement body and not to the changes to the agreement itself. And I would not say whether it's good or not, but it's in my opinion, in my personal opinion, it's changing of the system and the framework by case decision, which makes, first of all, it makes the system more complex to understand. Second, makes the system less predictable. You could be in the situation when you start any agency, any investigative authority could be in a situation when it starts investigation, thinking of the requirements at one level, and at the end of the investigation there would be an issued report. After reading it, you understand that you were not correct in certain aspects. Maybe it's a normal situation, but in my opinion, while Doha Round is not moving on, the situation is changed and the legislation is changed, the provisions are changed by interpretation of it. So is it somehow discussed, or such a factor is discussed in the negotiations on rules or not?
Not openly. There hasn't been any discussion on these lines. Now, personally, I can see an interacting with lots of people, senior people from investigating authorities. My sense is increasingly that there is a little bit of uneasiness creeping in with how jurisprudence has dealt with some of the issues. To come back to my previous comment on uncertainty, and that's unpredictability, because that is why you have dispute settlement, is to have predictability and certainty. You might not always agree with what a panel or appellate body has said or ruled, but at least to have some certainty and clarity. Now, where we have a problem with let's call it rulemaking in the WTO, that's a preserve of the members. The members negotiate agreements, and they the guardians of these agreements. Now, if there is interpretation of the way how they perceive the agreements to be interpreted, and they don't agree with it, then of course they can always go back and change the agreements. Now, we know that in the instance of the DDA, it's been ongoing for 14 years. When you have a parliament or a piece of legislation, and there's a problem in the way how it has been interpreted by a court of law, even the highest court in any country, you just get Parliament together and you say, okay, there's been uncertainty, we were not that clear in our legislation, let's change it. And there is sort of, there's particularly one country very strongly of the view that the jurisprudence has started to fill the gaps. Now, I cannot comment on that, but it is a view held quite strongly by one particular member, and some other members also sort of expressing some concerns. But I think it is something that perhaps members will have to address in the negotiations.
Thank you. Would there any other questions on Doha Round issues? Or should we proceed with go to the next question session? Okay, let's start the next one, which is supposed to be devoted to the transparency due process. And could we ask Mr. Dadu to moderate and start it?
Well, as I mentioned in my first presentation, confidentiality aspect is one of the major challenges that we face in the large number of cases that we do. Now, what exactly is confidential information? In the mind of the DGAD of India, any information disclosure which is likely to have an adverse effect upon the supplier or the source of such information is termed as confidential information. Now, most of us are aware that submission of confidential information is required at various stages of the investigation, starting with the initiation, where the domestic producer has to file both the CV and the non-CV versions. Secondly, at the time of the questionnaire responses, CV and NCV versions have to be submitted. At the time of the oral hearing, CV and NCV versions have to be submitted. Then, when the disclosure statement is issued, the comments and views have to come both in the CV and the NCV version, and any other submissions that are required to be made have to be made in both versions. Now, the interested parties must provide non-confidential summarization of all the confidential data, unless the parties are able to demonstrate that the information is not amenable to such summary. And if they say so, then they have to provide justification for the same. It is the right of the investigating authority to discard any information if the test of confidentiality is not found valid, and if the request for confidentiality is not warranted. Confidentiality in internal documents such as verification reports, other internal documents, import statistics from other sources, etc., are important. Now, the issues relating to use of confidential information in our system follow the following three criteria. can the confidential information received from independent sources may be used in any other AD investigation? Number 2, can the confidential information received from other independent sources be used for other purposes than AD investigation? And third, how to apply the test of by nature confidential information in any investigation. Confidentiality and disclosure of calculation of injury and dumping margins, calculations of net injurious price or fair selling price, injury margin, dumping margin, and disclosure of calculation to the interested parties on the basis of which such determination is made. So these are some of the things which I thought I'll highlight with respect to confidentiality and transparency. If we just look at the transparency issues in a little more detail, the most important thing to our mind is the number of stages where full transparency procedures are followed. For example, at the time of initiation, 40 days time is given to all the stakeholders to submit their responses. Thereafter, the domestic verification is done, the exporter verification is done, and both parties are allowed sufficient time to give their comments on these verifications. When the oral hearing takes place, all stakeholders sit before the designated authority and can say whatever that comes to their mind, which is pertinent to the case. They are also then allowed to give written submissions transparently to the designated authority within a period of time. Finally, when the disclosure statement is issued, again adequate time is allowed to all the stakeholders to submit whatever they want to say. So the transparency procedures are followed strictly as per the WTO regulations, and I don't think we have anything to quarrel about with respect to that. With these words, I think I'll stop and I'll request the South African colleague to, Brazil to make its first intervention on this.
Yes. Thank you, Mr. Dato. Good morning again. On the topic of due process and transparency, I'd like to mention how the rules work in Brazil. Whenever a part has possibility to submit confidential information, the balance is struck between due process and transparency on the one hand, and the other hand, the right of the part to submit confidential information is altered. Therefore, both the agreement and the Brazilian rule developed some provisions in order to try to make this balance better. And these include the submission of non-confidential summaries. Therefore, this alternative method for ensuring due process and transparency needs to satisfy certain criteria. Non-confidential summaries needed to allow the other part to obtain a reasonable understanding of the information submitted in confidence and allow the other part to defend their interest. What happens in the COM is that whenever an information arrives, it can be the petition or exporter questionnaire, we scrutinize the formalities of the questionnaire, which includes all confidential information submitted. And then we assess whether exceptional circumstances exist, whether the exporter or the domestic industry give sufficient reasons in order to withhold that information from other parties, and whether they provide a detailed non-confidential summary which would allow other parties to understand and to the information provided in confidence and to defend their interest. And this is not acceptable in all cases, and mere allegations of the parties are not accepted as well. We only accept that non-confidential summaries are not submitted when in two situations, when non-confidential summaries would necessarily make it available for other parts, the sensitive information, and or otherwise would necessarily fail to summarize the information in order to allow the part to defend their interest. Under the Brazilian law, there are certain type of information that we do not consider as confidential, which includes information which is clearly of public domain, or which is related to the shareholding structure of the company, the corporate organization of the group, volume of production, domestic sales, exports, imports, and inventories, property, financial, and corporate statements of publicly held companies. And this goes both sides, for the domestic industry and for the exporters. In asking the information to be submitted, there are different forms that we can request. If we have numerical information, we normally request information to be summarized as a weighted average figure if it refers to price or totals, and this we can use this information in our preliminary and final determination that are published. So we do not change the way the parts summarize the information given. So there is certain information that we consider confidential by nature, and this information includes information that its disclosure would be of significant competitive advantage to a competitor, or would have a significantly adverse effect upon a person supplying the information or upon a person from which that person acquired that information. And there is the information that is properly treated as confidential. And this information needs to satisfy certain criteria, which include any type of information that the part submits as confidential, but then the needs to conclude that the request for confidentiality is granted, and that the part provides non-confidential summaries in sufficient detail, and this summaries is sufficient detail in order to allow other parts to understand the content that's submitted in confidence and allow other parts to defend their interests. And finally, under exceptional circumstances, the CON will accept a statement giving reasons why summarization is not possible. Thank you.
I now request China to make its intervention.
Thank you, India, and good morning to everyone. About the transparency in the due process. Excuse me. Okay. On the transparency and the due process, we think that the principle of transparency is a fundamental principle of World Trade Organization. It is embodied in almost every agreement and every area of WTO regime. In trade remedy, transparency is also a very important principle, and there are many articles and provisions in the relevant agreements of the WTO, such as anti-dumping agreement, agreement on subsidy and countervailing measure, and also the safeguard agreement. These provisions and articles will ensure all interest parties to interested party of a trade remedy case to have ample opportunity to access or check the relevant information about their case, and they can defend themselves properly. In China, we also, since the establishment of the Chinese trade remedy system, Ministry of Commerce, the Chinese Investigating Authority, has always been attaching great importance to trade transparency and due process issues. And we always try to improve our practice and enhancing the transparency to protect the interest parties' right. Firstly, China has promulgated several rules and regulations regarding the transparency and due process, such as the provisional rules on disclosure of information in anti-dumping investigation, and provisional rules on access to non-confidential information in anti-dumping investigation, and also the provisional provisions on information access and disclosure on investigation of injury. These rules and regulations will build up a basic rules and regulations on information disclosure, access to the public information, and how to trade, the treatment of confidential information, and also the definition of essential facts based on which the dumping and injury was determined. And secondly, during the process of investigation and determination, we have a lot of method to ensure the transparency. From the very beginning of a case, if a domestic industry file a petition to the investigating authority, we will examine whether the information has properly documented. If we decide to initiate the case, we will issue public notice, and at the same time we will put the petition book on our official website, so any interest party can access to our official website to check, to get the public version of the petition book. And even the interest party often, and also the non-interest party can also access to that official website. And after the initiation, we have 20 days for a period for any interest party to respond to us. And during these 20 days, they can comment on the issues relating to the initiation. For example, if you have any opinion on the scope of product condition, and also you have a opinion regarding the threshold of the petition, you can have this opportunity to comment on that. And after that, we will carry out we will send out the questionnaire, and 37 days later, the interest party responds to the questionnaire. We will put all this, the public version of this response, to the public reading room of the trade remedy investigation, and allow each interest party to access to that public reading room to check this information. And before the after the preliminary determination, almost the same time, we will disclose the information to the interest party to say how we calculate dumping margin, how we calculate the injury, and how we decide whether it's not, there's a dumping or not, there's an injury or not. And after this, we can also hold a public hearing to give the interest party the opportunity to hear between each other. And also, after the on-spot verification, we will make a disclosure about the result of this on-spot verification, and allowing interest party to comment on that. And during the and in the determination, the authority will also respond the comments and claims by the interested party about their views. If somebody, for example, if a exporter responder claim that one particular things, we in the final determination or preliminary determination, we will say what we have treated them. We accept them or we don't accept them, and give the reason about this. About the information disclosure, the Article 6.9 of the Anti-Dumping Agreement stipulates the rules about the information disclosure. And in that article it said that the IA has the obligation to inform all interested parties of the essential facts under consideration which form the basis for the decision whether to apply a definitive measure before a final determination is made. And such disclosure should take place in sufficient time for the parties to defend their interest. And China also, firstly, China has the similar regulation about this information disclosure. And in practice, the investigation authority will disclose to the interested party the information. In Article 5 of Preliminary Rules on Disclosure of Information in Anti-Dumping Investigation, it says that information which is contained in the disclosure after a preliminary determination and before the final determination is made should include the following elements. Regarding the normal value, the investigating authority will disclose to the relevant interested party how the normal value is established and all the transaction data submitted, and whether this data has been adopted or adjusted for calculation of normal value, and also the reason for reject or adopt. For the export price side, the authority also should disclose the information how the export price is established, and how this transaction be treated, is adopted or adjusted in calculating the export price, and also the reason of that. And regarding the cost data, and the authority should also disclose to the interested party that how the investigation authority treat this cost data. It will accept this or allocate or adjust this cost data, and how they determine the cost production plus reasonable SG&A, and how they get this figure. And besides this, the IA will also disclose the if in the determination the IA decide to use best information available to get a conclusion, and they have to disclose that what kind of information the IA has used, and the reason why the IA used facts and information available, and also the methodology for calculating the dumping margin. We use weighted average to weighted average comparison, or weighted average to individual comparison, or individual to individual comparison to calculate dumping margin. And for the disclosure after the on-spot verification, disclosure should include the following. First, whether the exporter or producer subject to the verification has been cooperative or not, and whether the data information material provided by such importer are genuine, accurate, and complete. and whether the investigating authority has collected further information during the process of the verification. Next one is about confidential information. And according to the WTO rules and the relevant Chinese law, the confidential information within the meaning of the trade remedy case normally is include the two separate categories. First one is information by nature. Second one is confidential information provided on a confidential basis. The information by nature, such as we think, such as the individual transaction price, or the custom name, or this kind of information has a basic value in that. If the other party get this information, it's not good for this information. So it's information by the confidential by nature. The other kind of information is confidential is information submitted on a confidential basis. If the interested party submitted the information, claim that it is a confidential information, normally we will treat them a confidential information. However, we will also check whether the reason is good or not. For example, I will give you an example. If the information submitted, if the party is a public-sized company, they submitted a accounting book. How to say it? If a public-sized company, if that information can be accessed in the newspaper, that kind of information cannot be treated as confidential information. And also the information, if a party submits confidential information, they have to also submit a non-confidential summary thereof, and to allowing other parties to get a reasonable understanding of this information, so the other parties can use this information to defend themselves. So this is how China. This is the practice of China in dealing with the transparency and the due process issues. Thank you.
Thank you, China. I think for the sake of getting the presentations cleared first, we may take the questions later, and I would now request EEC Vladimir to make his presentation.
Thank you. I would try to be quite short due to the lunchtime in my presentation. What I wanted to stop on, Eurasian Economic Commission is trying to fulfill all the obligation on disclosure of information, and we follow. Looks like it's. What do we disclose? First of all, before initiation, we disclose to the members of the union the non-confidential versions of application, which is submitted to us by domestic industry. And after initiation, we publish quite a detailed public notice with the evidence submitted, with the description of the evidence submitted in the application, with regards to the main elements of the complaints. And the non-confidential version of complaints sent to known exporters and to the authorities of the countries which are mentioned in the complaint. During the investigation, we provide access to any information provided and presented to us by any interested party in writing, and to any other information used by the by our authority, which is not confidential. Before determination, before the final determination, we publish a separate report, which actually corresponds to the requirements for essential facts in the respective provisions of the anti-dumping agreement. And after the decision, the final version of such report is published, which contains also the comments and the answers to the comments by the authority. I mean, the comments by the interested parties and our responses to these comments, to the version of the report which is published before the determination. And of course, the public notice upon the decision is with short description of the results is published also on the website of the Commission. The main resource of the information which is disclosed is the report. The reports which are published by the Commission are usually quite detailed. In certain cases, they are more than 100 pages in length. So we try to describe every moment and every argument and every problem we faced in the investigation, to not only for the issues of transparency, but also for certain type of keeping the records of the investigations, which is more convenient in our opinion to do it in such a manner. With respect to a bit more details on disclosures. First of all, we disclose the dumping calculations, the factual dumping calculations in Excel files with all the data used from the questionnaires, with all the calculations and adjustments and everything which is made by the authorities sent to the respective exporter for the comments, and all the comments are taken into account on regular basis. We even change the calculations after the comments. With respect to injury causality calculations in data, they are reflected in the report sent in confidential version to the respective producers. And the reports contain all the information which is treated by us as confidential in non-confidential version. On a general basis, it's the data which is indexed year by year and with respect to the first year of the period. Technically, what we do is we send the reports to the registered participants in paper, and we publish them on the Eurasian Economic Commission website. So it's available to anybody who wants to get access to. What I would like to mention is that we are changing the system quite significantly in terms of the access to the information contained in the non-confidential dossier. In all new investigations we are starting right now, we are starting to use access, to provide access to the non-confidential dossier through the website of the Commission. So interested
bodies, participants to the investigations, could get access to the personal cabinet of the particular investigation, and all the non-confidential data and papers and letters we receive in the investigation published there, so they could be accessed to. They are published in PDF or Excel format, depending on the format which is provided to us. I would like to spend some time on problems we face with respect to the issues related to the access to information. First of all, we see some problems in the latest decisions of dispute settlement body with respect to these issues. The position, which is right now is established, is that the treatment for all the data, like the data which is provided by companies in the investigation, should be treated equally for all the companies in one. If one company treats a certain type of information as confidential, other participants could not do it otherwise. But in our opinion, it's one of the questions to be discussed, because it could be a different situation for the different companies. For one company, it could be commercially sensitive information. For others, it could be quite they could agree with opening this information to almost to public. We face this problem quite regularly in the investigations, and something should be done, in our opinion, in WTO with this. Another issue is that we conduct quite complex work, spend quite a lot of efforts on manually purifying customs data to evaluate the exact volumes of imports and exports. So we receive the data from customs, we analyze the data on the level of separate declarations, and regularly we understand that these analysis should be done by not only by the harmonized system codes, but by looking at in details at the description of the products, to understand whether this particular shipment is the shipment of the product or some other products which are not under the scope of the investigation. And the results and of this analysis is confidential by Eurasian Economic Law, because we receive this data on confidential basis from the customs officials, and we could not disclose this data by our law. Another issue we face some problems, and we have some questions on that also, is that when we use aggregated data from companies, from several companies in the investigations, for example, 4 or 5 companies, in many jurisdictions, many agencies treat this situation as the situation when such information is not confidential, because it's aggregated information related to several companies. But we faced some problems with that, with such an approach, because in some cases, in one investigation we are just finishing right now, the problem for us that is, out of 4 companies, 2 companies consider the information as confidential, and other 2 have supplied almost all the responses to questionnaires on non-confidential basis. And if we use aggregate data as not confidential, as open data in the final report, we would allow 2 companies which treat this
information as confidential to calculate the information of each other competitor. So if we open this aggregated information, we actually would open the data which is provided to us on confidential basis. So for us, of course, we don't have such a long-standing practice as some other agencies, but even our experience shows to us that it's something to be done with that, probably even in further negotiations. So that's we wanted to probably discuss further with our colleagues from other agencies. Thank you.
May I now request South Africa to make its presentation?
Thanks, Mr. Dadu. I'm going to be really very short. I know some of you are probably already dying of hunger. And confidentiality is something that is dealt with very extensively in the anti-dumping agreement. The provisions are Article 6, 6.2, 651, where it tells us how you have to deal with confidential information and how you have to protect information on which confidentiality is claimed. But also as Article 6.2 provides that you must give parties an opportunity to defend their interests. And obviously if they don't have access to information, it would be very difficult for them to have that opportunity. And that's where the non-confidential summaries comes very handy and becomes a reality that we have to deal with. Sometimes easier, like Vladimir is saying, sometimes easier than in other instances. The requirement is that you have to provide it in sufficient detail for a party to know what the case is against him. And while the reality is that in certain circumstances that is just not possible. And the agreement recognizes that in saying that where it's not possible to summarize, you have to provide reasons why it is not possible. Our domestic legislation mirrors this. The Act provides that you have to identify information that you regard as confidential and that you want to be treated as confidential. You have to make a written statement in each such instance to say why information is confidential, whether by nature or otherwise. And you have to provide a written abstract or a sworn statement in our instance in terms of our law. Written abstracts will also vary. Sometimes it's really just a paragraph or a sentence describing the information. In instances where you have information of more than 1 year, you can index information, and we also require indexing of such information. Our regulations provide information that is normally regarded as by nature confidential. I've listed there the types of information. It really also will depend on the particular case, but normally it would be management accounts, financial accounts of a private company, sales volumes, costing, and so on. And it will also require a company to say why the information in this particular instance is sensitive and why this disclosure would be at disadvantage to him. I thought it might be just helpful or interesting to show you what a sworn statement in terms of our legislation looks like. This is one of our recent cases where the chief executive of the company concerned will make a declaration listing the types of information that he's claiming confidentiality on. He will list the different paragraphs. He will also say what is the type of information, what the basis is, why he is claiming confidentiality. And these are now the types of claims that the Commission will look at and decide whether we accept this claim of confidentiality or not. He's also then required to make a sworn affidavit in front of a notary. In practice, sometimes it happens that information that is claimed to be confidential, a third party wants access to. It happens more and more now for us. Our legislation provides for a mediation process where the Commission will mediate between the owner of the information and the person that wants the access. That has never been successful, for obvious reasons. Parties don't want their information to be made available. The legislation then provides that you can approach the High Court to seek an order to make the information available. We've been in court in this field for quite a number of times. And normally the court will issue an order stating what particular information must be available to what particular people, and normally the legal representatives of the companies concerned, and also making it very clear that it is for a particular purpose. And normally it would be for a judicial review after a decision is made. So yeah, that is in summary our dealing with confidentiality.
The floor is now open to questions. You can address the questions to any of the 5 BRIC countries.
Thank you, Mr. Tadu, and thank you to the presenters for the very interesting and different approaches, I might say, to what disclosures are. I was particularly interested in one sentence, in one issue, where Brazil mentioned that there is a particular set of information that they will never consider as confidential, such as volumes, corporate structures, shareholder structures, things like that. Would you say that this is mentioned somewhere in the regulations? So is it officially stipulated that if a company comes and says, listen, I don't want to open my output volumes or production volumes, you tell them, listen, but we have the rule where we simply would not accept you to make this information confidential. Do you use a rule, a written rule, or is it just a practice of the investigating authority that you do not generally do this? And also to other presenters, if they can comment, if there is any piece of information that they would not consider as confidential under any circumstances. Thank you.
Thank you, Maxim. In the case of Brazil, we have this provision introduced in our new legislation in 2013. So all this information must be provided on a non-confidential basis. So, and I mean here totals, not volume per product type or detailed information, but totals, we require them to be provided in a non-confidential basis. And it's in our law.
Anything on the website in the public domain cannot obviously be called confidential. I think that's the ground rule that we follow. Although case-to-case specifics are different, and if there's a justification, one has to examine it, but generally speaking, that would be true.
My question to Brazil.
Oh, sorry. Our practice is quite similar with others, and if information can be accessed in the public, so that kind of information cannot be confidential. And but sometimes it has confusing about this. For example, sometimes a company submits information and the other party said, no, it's not. But in that situation, we will discuss with both parties and to give us more reason why it's confidential or why it's not confidential. Then we decide whether it's not. Thank you.
Would South Africa like to respond?
Thank
thanks. Yeah, I think we've dealt with that extensively in our presentation. There are not information that we will never regard as confidential. There are information that we, as a rule, will regard as confidential, but it really depends on a case-by-case basis and reasons for claiming confidentiality.
Are there any other questions from the floor? Yeah.
Thank you. I think 3 questions again, if I may. One is on the time scope. Under all of your jurisdictions, when does the right of access start? What I mean is, can I access the pre-initiation documents? Because it's a usual practice, there is a back and forth between the domestic industry and the investigating authority. It's a matter of life. A lot of things are changed, and they may be quite interesting and relevant for what happens subsequently in the investigation. And a subset of the same question in the jurisdictions, and I think pretty much all of you apply the expiry review upon the initiation from the domestic industries. The same question, do the interested parties have a right to access pre-expiry review initiation documents? That's one question. The second question is whether under your domestic law, assume there's a WTO proceeding which is adverse to your investigating authority. Under your domestic law, can you hand over to the panel the confidential documents from the record in order to support or to rebut certain findings? And actually, a subset, one question to Mr. Human in this regard. I don't know if you know out of the top of your head, but how often do we have the business confidential information being part of the panel proceedings on the anti-dumping measures? Because from what I see, sometimes there is a BCI information being exchanged by the parties. That certainly facilitates the argument, but it's obviously not always possible, and not always typically the respondents cooperate in this regard. Thank you.
Well, let me answer your first 2 questions. Access in our system starts only after initiation. Because if the case is not initiated, what do you give access to? We may not initiate a case. So once the initiation starts, the access is possible. To answer your second question, we don't allow the CV version to be given to anyone except if there's a litigation in the court. There we give it in a sealed cover for the honorable judge to adjudicate. That's our position.
In the Brazilian practice, an interested party may have access to all information which is part of the petition, of the application. Then all these documents make part of a pre-initiation of investigation, so interested parties may have access to these informations as long as they are non-confidential information. And this goes as well the same way to pre-expiry review documents. In the case of Brazil, we conduct on-the-spot verifications on sunset reviews before initiation. Therefore, all parts interested in the process can have access to these informations as well. And of course, all our confidential file may be submitted to the DSB if Brazil is requested.
Yeah, well, ours is probably a combination between India and Brazil. We normally don't, as a general rule, put on the public file information pre-initiation, so we start on initiation. But it does happen that parties want access to, say, for instance, verification reports or documents, and we make them available. I think it's just a practical reason more than a access reason. Like Mr. Dadu was saying, sometimes investigations aren't initiated, or they're initiated 9 months or a year after the first application came. That there might have been 2 or 3 versions. So it's more a practical reason, I would say, than a access reason. In terms of our disputes, also we don't hand over confidential information to the panel members, only non-confidential.
For our practice is, I should say, similar to other members. And for the first question, yes, the inter-party can only access the information after the initiation. And we have a public reading room, especially for the information, access to the information. During the whole process of the investigation proceedings, each information submitted to us should be accompanied with, it should be also have a public version. When we receive that information, we will put the public version of that information to the public reading room, and every other interested party can go to the public reading room and to access that information. So after when the interested party submit the answer to the questionnaire, they can we will put that in the public reading room, and other interested party can access to that. And after the preliminary determination, we will put the disclosure to the public reading room, and also before the final, they also in the public reading room, everybody can check that. For the second issue is that we treat confidential information very seriously, even in the court proceedings. In our legal proceeding, we have if a administrative suit against us, if involved in confidential information, that proceeding, the court proceeding, can be operated in a confidential way. So not the public cannot get that confidential information. Thank you.
On your question on panels, what we find these days almost routine for either or both parties to dispute to request special working procedures to deal with confidential information, because you have to have for the panel to really adjudicate. So usually you'll find in working procedures what we call business confidential information procedures, and that's we have sort of a standard set. But panels can deviate from that depending on the demands from the parties, and there are strict rules then on how to deal with business confidential information, also the destruction of the information. And what will normally happen is that the interim report developed by the panel will contain business confidential information made available to the parties, and then they comment. But the final version going to all members, business confidential information is redacted from the final version. But it's almost standard now when there's an anti-dumping investigation or a CVD investigation to have special BCI procedures.
And in our practice, any interested person, any interested party could get access to the information received by us during the investigation. So the information received or sent to us before the investigation or before the initiation of the sunset investigation is not available. With respect to confidential information, it's available only to the investigation team. On the particular case, confidential information is not available to others in the department, only to the particular team who is responsible for this particular investigation. It's available to the commissioners in the form of the confidential version of final report, which they receive before the decision is taken for analysis. And the confidential information could be available to the court under the special procedure, so they could review it in camera.
Are there any other questions before we wind up for the lunch?
I have only one question. As per the agreement, the authorities are required to disclose the non-confidential information furnished by one interested party to other interested parties. But does any authority, like while conducting investigation, the authority gathers many kind of information from different departments, from different authorities. So whether such information is also required to be disclosed to the interested parties. This question for all the presenters, because this is a practical question. When we conduct investigation, then we conduct investigation on the basis of collecting transaction-wise import data from the data developing authority. There are at times questions come when interested parties ask for the transaction-wise data, and that is not supposed to be revealed. I want to know what is the practice in other countries.
Sorry, could you rephrase your question because I couldn't understand?
No, it's a specific question. Let's say I would like to ask Brazil. While conducting, you are supposed to reveal the non-confidential information given by one interested party to the other interested parties. But while conducting investigation, you also collect a lot of information. Let's say the transaction-wise import data on the basis of which investigation is conducted. Do you reveal the non-confidential version of the transaction-wise data to the interested parties?
Even if you collect data that will prove that information from another source, we only make it available if the part that submitted the information provided this information on a non-confidential basis. However, if you find this information on a public available site or website, we make it available. We never disclose the information from one part if this part does not make this information non-confidential.
Maybe just as a general rule, if information is taken into account by the Commission in making its decision, then administrative justice require that you make that information available to another party. So the same rules will apply whether you are collecting this information yourself from other parties or whether parties willingly submit information to you. And the same rules on confidentiality will apply. If someone like another State Department or national authority provide information on a confidential basis, the same rules will apply. They must provide non-confidential versions and parties must have access. Otherwise, the Commission or an authority makes a decision based on information that a party did not have access to, which could not be regarded as fair practice.
As regards us, we provide access to any information which we use in the investigation, even though if it's received from other sources and its information is not confidential, and we rely upon it in our conclusions, it would be included into the non-confidential version. The CEO of the file, and it would be described in the final report.
In our practice, if the investigating authority collects information from other sources, and if the source is public available, so we will disclose that to the interested party. And if a company submit us information in a non-confidential basis, but if the investigating authority find that that information may contain some confidential information, we will ask them to check again whether this, for example, is an export transaction, individual transaction. We'll ask them whether this is confidential or not. If this company still insists it's non-confidential, we will treat it non-confidential. But if in that situation, usually they will recheck and maybe make a mistake. We will remind them to do that. Thank you.
Vladimir, I hand over to you now for any announcement you want.
Thank you. I would propose to interrupt for the lunch. You actually could have lunch here at the building on the first floor, and I would propose to start at 3:30 or later. What would you prefer? 3:30. Thank you.